Good afternoon, Ms. Hedrick and Mr. Evans. We want to thank you for agreeing to present your arguments today in this case by video conference, which we are live streaming to fulfill our obligation to have open courts in Tennessee. And we're thankful that you are willing to do it this way. We've heard numerous cases over the last 4 or 5 weeks and have had great success with it, and I'm sure we will today as well. The hearing today will be conducted in the same fashion as if you and we were in the courtroom. And as the appellant, Mr. Evans, you have 15 minutes, and I understand you are reserving 3 minutes for your rebuttal. And then, of course, Ms. Hedrick have 15 minutes for your argument as well. If there are no announcements, we'll ask Mr. Hibner to call the case.
In re Estate of Donald Cowan.
Mr. Evans, you have the floor.
Your Honor, Winston Evans, I represent the appellant. This case comes before the court on review of a Rule 12 motion to dismiss. Therefore, the extensive and specific allegations of the amended complaint must be taken as true, and the Cowan estate is entitled to all reasonable inferences which can be drawn from those allegations, which again must be taken as true. This case involves a quitclaim deed. Contrary to the insistence of Ruth Cowan, the court is not limited to the 4 corners of that quitclaim deed. For each of 4 reasons, this court may consider the allegations of the amended complaint, which, as I have said, must be taken as true. First reason, parole evidence is admissible to show the true consideration for the quitclaim deed. Was this quitclaim deed given as an outright gift, or was it given in exchange for the agreement that came from the appellee, Ruth Cowan, to provide?
Mr. Evans, assuming that that is true, can somebody who was not a party to the deed provide that evidence?
I don't know if I don't want to be dodging the question, but we're talking about evidence. We're not at that stage. We're on a Rule 12 motion, but I think people.
No, but you said that parole evidence is admissible.
Yes, Your Honor.
But how can that be admissible to vary the terms of the instrument if it's not given by a party to the instrument?
Oh, it doesn't have to be given by the party to the instrument. The parole evidence.
And why is that? Well,
you can have parole evidence to show the situation of the parties, the circumstances under which the transaction was made. Any proof, any witness can give that information. And again, we're on a Rule 12 motion. And because there's 4 exceptions here. One exception is to show the true consideration that was given for the deed. Second consideration is to support our claim or remedy, as they say, for a constructive trust. Third, as the Supreme Court recently said, even if the deed is unambiguous and even if there's an integration clause, parole evidence comes in to show the situation of the parties, the circumstances of the transaction, the situation of the parties. And fourth, it comes in to explain an ambiguity. And here, apparently, we do have an ambiguity because we've got a disagreement. They say, well, an enduring marriage is simply a long marriage. Well, that's incorrect because under that interpretation, then long is superfluous. It makes enduring superfluous because the consideration was in contemplation of a long and enduring marriage. And to give meaning to enduring, it has to be something other than long. And as we've suggested, steadfast, unwavering, unfaulting, things like that, to have an enduring marriage. You can't look at just the length of the marriage to determine whether a marriage is enduring. You have to look at the relationship between the parties. You have to look at things like, did the parties live together or were they inseparable? They live apart. As we've alleged, they lived apart. Was it a bitter marriage? Were they trusting of each other? Did it engender happiness? Was it a loving marriage? All of these things that come with an enduring marriage were all absent. This was a faithful.
Mr. Evans, how do we consider parole evidence that pertains to occurrences that occur after the deed is executed and recorded?
I would say you consider that to show the breach of the agreement, the breach of the fiduciary duty that existed between the parties. The parole evidence is the evidence to show what was the agreement that the parties made. Now, certainly,
Are you arguing that this was a conditional gift?
Yes, sir. I think that is one of our theories, and it was either a total or partial failure of consideration. And this is certainly falls.
Wouldn't that put every quitclaim deed that a parent gives to a child for love and respect and friendship in the place of being a conditional gift?
No, it wouldn't, Your Honor, because when it said the typical thing you see is in consideration of love and affection. Here, there's.
Well, what if the parent and the child get at odds over who the child picks as a spouse? That happens a lot. Are we going to revoke the deed?
Well, it depends on what the deed says. And here it says not only in love and affection, it went on to say in consideration of a long and in contemplation of a long and enduring marriage. And both counsel and the court, everybody admitted nobody had ever seen that before. We've got to explain what was the agreement of the parties. What was the motivation of the parties? And as we said, the agreement was that she would live with him and provide, as the deed says, an enduring marriage and all the things that come with an enduring marriage. That's what we're entitled to show. We're not limited to the four corners of the deed. This is not an outright gift where it just says love and affection and nothing else. But I would have to say, if there is, you've got the exception. It says you can show the true consideration for a deed, and that's settled law, that you can look behind the recited consideration in a deed to show that. Now, they say we haven't shown a claim for, or remedy, as they say, for unjust enrichment. Well, and constructive trust. Constructive trust is not limited to unjust enrichment. A constructive trust goes much further. It embraces anything that essentially results in something that would be an inequity. And here we've alleged she had no intention of living with him or acted like a wife should when she duped him into giving him the quitclaim deed. And furthermore, there was a breach of fiduciary duty. It's settled law in Tennessee that the husband and wife have a fiduciary duty that is of the highest order, and she breached that duty.
Well, what can we talk about the timing here? It was a 28-year marriage, and we've got latches and statute of limitations and what have you. What about those?
Statute of limitations, that's the Ashbacher case. This fits this case to a T. It's what was established by Ashbacher, and I forget the case that Ashbacher cited. It's the continuing contract document, continuing contract doctrine. And we've alleged it was a continuing contract specifically in our complaint. This is the Ashbacher case, and as far as laches, Your Honor, that's a mixed question of law and fact. And we don't have to plead that here. Number one, it's premature is what I'm trying to say. Number two, to have laches, you have to have an unexplained delay. And it's settled law in Tennessee, as well as a lot of other cases elsewhere, as we've cited, that a husband and wife are not required to sue each other during their marriage. That was contrary to public policy. So the delay that they complain about is excused. And we had exactly that situation, I believe, in the King versus King case. Now they talk about, well, you're prejudiced. They want the court to presume prejudice based on a case that's 108 years old or something like that. And we've cited the recent cases, which clearly say in Tennessee that to have prejudice, you have to show the prejudice. You can't just presume it. And the prejudice, they say, results from the death of Mr. Cowan. Well, wait a minute. What prejudice is that going to be to them? His testimony would be adverse. They've benefited from that. Then there's the death of attorney Ruth Kennard, who drew the deed. Well, nobody knows what Ruth Kennard's testimony would have been. For all this court knows, Ruth Kennard's testimony would have been favorable to the Cowan estate. And again, we're on a Rule 12 motion. We're not on a summary judgment. We're not after trial, and the allegations of the complaint have to be taken as true. So we've got the constructive trust theory. We've cited several cases which I think fit this case to a T, where when somebody makes an agreement that they're going to do something, and then the lady, this is the Middle District of Tennessee case, where the lady was going to have the horse farm with the gentleman from England, and he gave her the money. She was supposed to buy the horse farm in his name, and she didn't do it, bought it in her name, and then the romantic relationship broke up. And the judge from the Middle District said, I'm impressing a constructive trust on that property because the man in England paid for it. I'm making the defendant lady that duped him the trustee, and she has to convey it to him. And that's what should be done, we think, in this case, Your Honor. The statute of frauds doesn't apply. Among other things, there's complete performance by Mr. Cowan when he delivered the deed. And that takes it out of the statute of frauds right there. There's even examples from the restatement that we cited.
Mr. Evans, in that case involving the Englishman, were they both alive?
Yes, sir.
Okay.
Both alive. Yeah, everybody was alive the whole time. And
okay.
Again, Your Honor, it's our position that the parole evidence to show what the agreement of the parties was can be shown by people other than the parties to the deed. There can be other witnesses. And for right now, those allegations are in the complaint.
Well, who is going to be a witness as to what promise the wife may have made, or what promise the husband may have made, other than the wife or the husband?
Well, there can be witnesses to those promises being made. There can be statements that would come from either one of them that would constitute an admission. And we're on a Rule 12 motion. And I don't know if I'm getting through the court to that the allegations have to be taken as true at this point. Thank you.
All right. Thank you, Mr. Evans.
Thank you.
You'll have 3 minutes on rebuttal. And Ms. Hedrick, the floor is yours.
Thank you. Good afternoon, Your Honors. May it please the court, I'm Andrea Hedrick of Gullett, Sanford, Robinson, and Martin. Our firm represents Ruth Roberts Cowan. She's the widow and the defendant in the lawsuit. This is a lawsuit by a personal representative of an estate to attack the validity of a deed. It's interesting to note that during the nearly 3 decades that Mr. and Mrs. Cowan were married to each other, Mr. Cowan never filed a lawsuit about a supposed contract or about a violation of some condition of a deed. Rather, these issues were not raised until after Mr. Cowan's death. And
did Mr. and Mrs. Cowan have interaction during these 28 years?
Well, according, we must go on what's in the record and
right.
The petition or the complaint. And the complaint does allege that they had interaction, but it alleges that they had miserable interaction. It was a terrible marriage, and that my client is a terrible person and all kinds of nasty things. What it does not allege, however, is any kind of continuous relationship or communications related to this particular deed, and any contract or obligations under a contract or breach of a contract. And that's the distinguishing factor in that Ashbarger case. I may be mispronouncing That is Mr. Evans' argument about continuing obligation contracts. And the theory there by Mr. Evans is that, well, if it's a continuing obligation, then every time you don't perform the obligation, the clock starts ticking again on the statute of limitations. And what the trial court saw here is a big distinction between our case and the Ashburger case, and he noted several distinctions, but the key one was that in that case, there was no dispute that there was a contract. There was communication concerning the contract and obligations and the breach. Here, that's not what we have. We don't have a contract here. That's a fundamental difference. And we have an instrument, this deed, that has no evidence of a contract in it. And that's the distinction and why there's no continuous obligation. Now, Mr. Evans is right. This is a motion to dismiss. One thing to point out about the court's order is it has detailed findings of fact. It has very extensive legal analysis. The court did adopt as true the allegations of the complaint. And while my client would love me to dispute those allegations today, or many of them, we understand that's not what we're here to do today. And we'll be talking not about disputing the facts, but we'll be talking about the law applicable to those facts as alleged. Now, the trial court, as I'm sure your honors have read, dismissed this complaint on 5 different grounds. And I'll just very briefly summarize those grounds because they're important. First was based on the deed itself and the finding by the trial court that this was an unconditional gift and that the deed itself was not a contract between the parties. The second reason was rejection of the unjust enrichment claim. And what the trial court basically said is it's not enough to simply make a conclusory statement in a complaint. You have to actually allege the elements necessary to get past a Rule 12 motion there. And in this case, the personal representative did not do that. The third reason was rejection of the contract theories of the case. And that's all tied to the statute of frauds. And in a nutshell, the problem here is there is not a writing signed by Mrs. Cowan that evidences essential terms of a contract. What we have are 2 writings that Mr. Evans briefed. And one is a marriage certificate signed before the parties married in the first place. The other is the deed signed by Mr. Cowan months later. And what Mr. Evans attempted to do in his argument was to say, well, trial court, you need to look at those 2 instruments together because she signed the marriage certificate. And what the trial court did is said, look, I'm looking at these 2 documents. They're unrelated. There's no cross-referencing. They're not both signed by both of the parties. And under the elements, under Tennessee law, it's not appropriate to recognize those instruments together unless you can look at them and understand that they're connected and be able to extract the essential terms. Here, we can't do that. So the trial court rejected that argument. Moving on to the statute of limitations. So this is very, very important. We have a potential 3-year statute, 6-year statute, and 10-year statute. Literally all of the claims pursued here are barred by the statute of limitations. That's what the trial court said. But as to all of the non-contract claims, there's no defense to that. Even Mr. Evans can't defend dismissal of those. Where he's attempting to convince the court to give another chance is on the contract claim based on his continuous obligation theory. And we've already discussed why that one can't go forward. And finally, on the gross latches, this is fundamental. When the trial court looked at this, he said that there was nothing in this complaint, no facts alleged that would support or explain the reason for the 28-year delay. And Mr. Evans has come in now and said, well, okay, maybe the complaint doesn't allege facts to explain this away, but I'm going to make a public policy argument. I'm going to say that under Tennessee law, we don't encourage spouses to sue each other. And what he cites are a number of prenuptial agreement cases that say, don't sue over the prenup until after when it's finally time to divorce. But you have to also consider that argument along with what's in the complaint. And the public policy argument is, well, we don't want spouses to sue each other because it disrupts marital harmony, right? But if you look at the amended complaint, there, according to the personal representative, there is no marital harmony. This is the most miserable marriage in all of creation. And so you can't have it both ways, respectfully. You can't on the one hand say, well, it was miserable marriage, and on the other hand say, well, Mr. Cowan, I'm just going to guess that he didn't file suit because he wanted to maintain marital harmony. So that's the argument there. I'm going to attempt, in the interest of time, I wish I could talk about all of these intricacies, but I want to try to hit the high points of what the issues Mr. Evans raised. And first we go to the language of the deed itself and why this is so important. So remember, the deed is signed by Mr. Cowan and it's signed by Darlene Marsh. She was the notary public. It is not signed by Mrs. Cowan. And when you look at the language of the deed, the very first thing you see is this statement. It says, the actual consideration for this transaction is $-0. And below that, you have Mr. Cowan's signature, and it's notarized by Darlene Marsh. So he's stating to the world, the value of the consideration is $0. Then in the body, here's the important language we find in the deed. First is the phrase, for and in consideration of love and affection. Now, we all know that is standard boilerplate language in a gifting deed that you would give to a spouse, to a child, to anyone that you're not expecting anything in return. The trial court acknowledged that in his order. Even Mr. Evans would concede that that is standard boilerplate gifting language. So that tells us that's looking like a gifting deed. But then we have this next phrase, and here's where Mr. Evans and I kind of go on different paths. The next phrase is, in contemplation of a long and enduring marriage. So Mr. Evans thinks that word enduring is very important. Our position is it's not important at all, and here's why. What this states is that Mr. Cowan, when he signed the deed, at that moment, he contemplated having a long and enduring marriage. Whether he actually had one or not is totally irrelevant. Why? Because he didn't make this transfer subject to a condition that he have a long and enduring marriage. If language had been different, if it had said, provided I have a long and enduring marriage, or provided my wife provided services that allow me to have a long and enduring marriage, or some other language, we might have a different conversation. But all this tells us is that Mr. Cowan contemplated having a long and enduring marriage, but he didn't make the transaction subject to that occurring. So you can define it in the way that Mr. Evans suggests. That's fine. I'm happy to do that because, frankly, it's irrelevant in the analysis. So what we have here is a zero consideration deed. That's a gift. We have nothing in this deed that says there's a contract. Mr. Evans says you can go outside of the four corners of the deed to find the, quote, true consideration. But I want to talk about the types of cases he's citing for that proposition. He's looking at cases where perhaps the deed said for $1 or for $10 and other good and valuable consideration. And if there's a dispute, it would be proper to go outside of the four corners to find out, well, what was that other good and valuable consideration? But that's not what we have here. We have nothing in this deed that says for other good and valuable consideration. What we have is Mr. Cowan saying zero consideration of zero value. The next point I want to get to is, we talked about long and enduring marriage. What Mr. Evans said, I think I heard this right. What I believe he said is that he takes a position that this transaction and the gift, or excuse me, the transfer of the interest in property was subject to a condition, right? Now, he didn't use certain words there. What he's really asking the court to do is to imply what we call this goes back to property 101 in law school, right? That I've forgotten at least. He's asking the court to imply a condition subsequent, right? Where perhaps it says, this takes place unless a certain event occurs. Or in the alternative, he might be asking the court to impose a reverter, right? And a reverter is basically where it says, so this transfer occurs so long as the grantee performs a certain act or performs in some way. But why did he not use those particular words? Well, I'll tell you why. Because under Tennessee law, termination of estates and reverter clauses are not favored. They're strictly construed, they're narrowly construed, and in order to be valid, they must be clearly stated in the deed. There's the Baird versus Southern Railroad case, there's the Nashville Railroad case versus Bell, and there's Walker versus Shelby County School Board to support that proposition. Let's talk for a moment about the argument that Mr. Cowan fully performed his obligation and therefore it takes this out of the statute of frauds. Well, the case Mr. Evans cites on that is Vaughn versus King. Vaughn versus King is distinguishable from what we have here. In Vaughn versus King, it was a land deal where on the face of the deed, it was a contract and the consideration stated was $50,000. All parties knew and acknowledged there was a contract, knew the purchase price was $50,000, and the only issue there was whether or not the purchaser was in default of the payments. So the court said, you can look outside the four corners to figure out whether there's been a default. But again, that's not what we have here at all. We don't have a deed that has contract language. We have a dispute about whether a contract exists in the first place. And it's not about whether someone paid their stated purchase price on the deed. So that's the distinction we have there. And we discussed the continuing obligation contract. We discussed Mr. Evans's public policy argument. But in the time I have left, I want to make Mrs. Cowan's public policy argument. And that's this. And I think maybe Judge Jenkins touched on that earlier. If in fact this case can go forward, what's going to happen? Every disgruntled divorce litigant is going to run in the course of their divorce and want a re-examination of deeds and implied conditions that don't exist. Same could be true for mother and father that have a falling out with their child or any gratuitous transfer. It leads down that path. And so it's not just the divorce courts. It's not just the general civil courts. It's also the probate court. Judge Clement well knows that in the probate court, we have situations all the time where you have surviving spouses that don't get along with children of the decedent. And that's simply asking those cases to raise this type of issue and to flood the courts with this type of litigation.
All right. Thank you, Ms. Hedrick. Mr. Evans, you have 3 minutes for rebuttal.
King was cited, Brewer versus Ball. This is on complete performance. There's a case from Morgan. There's also the restatement we cited. This is on complete performance satisfies the statute of frauds. The waiver of the reverter argument clause, I may be mistaken, but that's the first I've ever heard of reverter. That's a new argument. They try to distinguish the fiduciary duty. They say that the trial court found this, the trial court's ruling this. I respectfully urge this court, don't be distracted by that. What the trial court did doesn't mean anything because this is a de novo review. We have alleged a contract, and I think the court has to be careful when they review the pleadings and the argument of the appellee. The appellee tries to take certain allegations of our complaint out of context and focus on narrow allegations, and as if that's the only allegation, and say, well, that's conclusory, that's not enough. If
Well,
you-
Mr. Evans, you have relied heavily on the argument that foreign consideration of love and affection and the contemplation of a long and enduring relationship as whether there was a default in the consideration. But what about the statement that the consideration is zero? How can you want us to say we have to accept this allegation is true when there's another piece of information in the documents you rely on that says, no, that's not true?
That's another argument that's been raised for the first time, number one. Number two, that there's no monetary consideration. That's why that's a zero. You can't put a value on that. I think that's what happened. And there's been, if you're going to get into that, now you're getting into a factual dispute and the evidence.
So you're going on the argument that courts should try to determine whether the love and companionship had value or sufficient value. How in the world, if you get past the Rule 12, how in the world does a court do that?
Well, the court will just have to listen to all the evidence. And if you see the allegations that we've made in the complaint, and they're detailed allegations, Your Honor, I think we will
Oh,
those. But that's
they're colorful.
another day.
Yeah, they're unflattering and colorful, and but you're asking the court to, in essence, monetize the value of love and affection.
No, what we're doing is asking the court to say there has been a failure of consideration to cancel the deed.
How do you do that if you don't monetize it?
You don't have to monetize it to cancel the deed. You don't have to do that to impose a constructive trust, Your Honor.
But don't you have to determine that it was inadequate consideration?
If you please read the cases we've cited on the partial failure of consideration. If it's only a partial failure of consideration, if it goes to the heart of the deal, a partial failure of consideration is enough for rescission.
But how does a judge today decide whether there was partial consideration when Mr. Cowan never did anything about it?
But again, that gets to the laches, and you can't just.
No, you're arguing the consideration was inadequate. How in the world do we make a determination, assuming we get past Rule 12? How in the world does it make that determination?
Well, there's going to be a failure of consideration. Now, I don't know if I'm communicating with the court, but that's another day. When she agreed to live with him and have an enduring marriage. She didn't do either of those things or any of that. It's crystal clear.
Well, thank you, Mr. Evans and Ms. Hedrick. You've both been very persuasive in your arguments this afternoon, and we will take this matter under advisement. Mr. Hivner?
Thank you.
This honorable court is now adjourned.
Thank you.